Hey everybody, John Skiba here from the Arizona Consumer Law Group. And in this video, I'm going to teach you how to cross-examine a debt collector like a pro. But if this is your first time here to my YouTube channel, go ahead and click subscribe, click on the little bell, and that way you'll be notified each and every week when I put out a new video that's going to help you solve your serious debt problem. All right, let's talk about cross-examination. This is always the most dramatic part of any lawyer movie where the lawyer goes up there and cross-examines a witness and the case gets blown up and it's very exciting and dramatic. It's not quite as dramatic in a junk debt buyer trial, and that's going to be the focus of my video here today, is those of you who are being sued by a junk debt buyer like Midland Funding, Portfolio Recovery, maybe a student loan debt buyer like National Collegiate Student Loan Trust. I'm going to talk to you and teach you about how you can do a cross-examination effectively if your case actually goes to trial. If you're representing yourself, trial is probably the most scary part of the whole thing and is producing a lot of anxiety. But if you know exactly what you need to say and the approach that you need to take when you're in trial and what you're trying to accomplish, it can alleviate a lot of that anxiety. So let's talk big picture first, as far as what you are hoping to accomplish when you are cross-examining a witness that's been called on behalf of a junk debt buyer. So if we set the stage a bit, you're in trial, the plaintiff, let's say the plaintiff is a junk debt buyer like Midland Funding. Midland Funding has their witness, usually it's over the telephone, most courts will permit that with debt buyer cases, or they may be there in person. But their attorney is going to go first. I'm going to walk them through various documents and exhibits that they have. I'm going to talk to them about information, about the amounts owed, how it is that the debt buyer, Midland Funding, how it is that they're claiming ownership of it. And then the judge is going to say, they're going to ask you if you have any cross-examination. If you want to ask the witness from Midland Funding or whoever the debt buyer is, if you want to ask them questions about what it is that they just testified about. Now, the big picture here is you need to know and be going into the cross-examination with a plan as far as what do you want to accomplish by asking the questions that you're going to ask. And the main thing that you're looking at here is that Midland has this problem, and any debt buyer does. They didn't loan you money, you didn't agree to pay them money, and so they've got to establish somehow why it is that they're entitled to payment. And they try to do that using documents that were produced by the original creditor. Say the original creditor was Citibank. They're going to provide these Citibank monthly statements. There may be a bill of sale or an affidavit from someone at Citibank. But they're not going to have someone from Citibank come in and testify at trial. It's not going to happen. I've done thousands of these cases. Never happened once. The original creditor is not going to come in and testify. And so they try to kind of just bootstrap this with having their own witness testify about these documents. Your goal should be to show the court that the witness for the debt buyer has no idea what they're talking about, that they're just parroting words off of a page. They're looking at these monthly statements and essentially reading them back to the court. They don't have any independent knowledge about how the debt was incurred, how much is owed, whether the documents are reliable. They really don't have any of that information. They're going to make it sound like they do. So it's your job in cross-examination to show the court that they literally don't know what they're talking about, and thus hopefully keep some of those documents out or at least undermine their testimony a bit to the court. So that's your big picture, is showing the court that they don't know what it is that they're talking about. Now, there are some rules about cross-examination. Typically, the cross-examination is limited in scope. In some states, you can't ask questions that are outside the scope of what the plaintiff's attorney had asked them. However, what I'm going to recommend and the questions I'm going to give you today are going to be right narrowly focused, and so that's not going to be a problem. Also, a general rule, one of the rules you learn first as an attorney, is that you should never ask a question to a witness on cross-examination that you don't already know the answer to. So you need to know the answer before you even ask them. And the reason why is because you're not really there to elicit information from them. That's what discovery is for. You're there to really craft the narrative and control the narrative about what it is they're saying and the message that you want being delivered to the court. And so you can do that through leading questions. Now, when direct examination, leading questions are not permitted. An example of a leading question is where you're essentially assuming or putting the facts into the question and just trying to get them to agree with it. Like by saying, the car was red, correct? That's a leading question. A non-leading question would be, what color was the car? On cross-examination, you want to ask leading questions. They're permitted on cross-examination. And in fact, most of your questions, if they're not leading, you're probably doing it wrong. The problem that you run into with debt buyer cases and debt collection cases is there's generally not a lot of discovery that's done. And discovery is the time when you usually get that information so that you know what the answer is before you even ask them. So this is where this video is going to be really helpful, because I'm going to give you a handful of the questions that I ask in every single cross-examination that I've ever done. And I know what the answer is because I've done so many of these and I've done the discovery. And the nice thing about debt buyer cases is they're pretty much all the same. All the facts, the way that the companies handle things, the way that the documentation that they have, the limited knowledge of their witnesses, all of that is very similar. So I can give you the questions that I ask when I do cross-examination at trial that have been most effective at showing the court that this witness has no idea what they're talking about. So let's jump into those specific questions. I even wrote them all down here on my yellow pad so we can go over them specifically. But one of my favorite questions is the very first question I ask on cross-examination. I always stand up to the witness or on the phone if they're telephonically and say, in preparation for your testimony today, did you review the documents or exhibits that you just went over with your attorney? Now, these are the exhibits, the monthly statements, the bill of sale, all that kind of stuff. I always, their attorney's going to have to get that admitted into evidence, so they would have already just gone over all those documents in their direct examination of this witness. So my first question is, did you review those documents prior to your testimony today? And they're always going to say, yes, I did. The follow-up question is the one that I love. I always say, when did that happen? And 9 times out of 10, that happened about an hour before they called into that trial or that hearing, whatever it is. And then I do a follow-up question. So I say, when did you review these prior to trial? Yes, I did. And then I ask them, when did that happen? That happened about 2 hours ago. And then I say, before 2 hours ago when you reviewed those documents, did you at any time ever review any of these documents or have any interaction with this case? And 99% of the time, their answer is no. They may say, oh, well, I looked at it, a couple months ago, but generally 99% of the time they're going to say no, that they've had no interaction. And the reason is the witness that the debt buyer's calling, they are essentially just a professional witness. They just show up to trial, they look at documents, and they've been trained on how to parrot the information that's in the document itself. But they don't have any specific information. They have never looked at this case before. And so that's one place where you can show the court that, look, and I've even said this to courts. I've said to the judge and I've said to opposing counsel in my closing argument, I'll say, look, the truth of the matter is the judge and the 2 attorneys in this case have spent more times with these documents than that witness had. We've spent months litigating this case, and this witness looked at these this morning and came in as their supposed expert to be able to lay foundation and testify as to dollar amounts owed, and that's problematic for them. So that's the first line of questioning that I go through. Then I'll ask them if they have ever been employed by the original creditor. So let's say that the original creditor was Citibank or Wells Fargo or Chase. I'll just ask them, have you ever been employed by Citibank? The answer is always going to be no. Then I'll ask them, has Citibank ever trained you in how they keep and maintain their business records? Again, the answer is no. That question you've got to be a little careful on. Don't ask them, have they ever been trained on how Citibank keeps and maintains their records? Because they may come back and say yes, and they may say that my employer did that, Midland Funding or Portfolio Recovery. They trained me. You want to ask us specifically, has Citibank, has Wells Fargo, has Chase, have they ever trained you on how that entity, how Citibank, how Chase, how Wells Fargo, how they keep and maintain their records? The answer is going to be no, that they don't have any idea how that original creditor keeps and maintains their business records. And then I asked them if prior to their testimony at trial, if they personally reached out to the original creditor to verify the amounts owed. Did they call anybody up, pick up the phone just to say, hey, is $5,697, is that the appropriate amount that we should be suing for? The answer is always going to be no. They don't do that. They don't do anything. Again, they probably looked at these documents just a couple hours before the trial started. They didn't do anything to actually verify the information. And you need to be careful of just not going too far. Sometimes you can ask too many questions. You don't want to say, did you verify that information? the answer is going to be no, then move on. You don't need to go in and then say, well, how do you know then? One, because you don't know the answer to that question. They may be able to come in and offer something that's somewhat acceptable to the court, even though it's probably not, but it may be. So you don't even need to go there. Just let it linger out there that the fact that they did not do anything to go in and confirm what the balance owed is. Now, this next one's a little bit tricky, but in the bill of sale, in every single debt buyer case, there's a bill of sale, and it's just kind of generic. It's usually a 1 or a 2-page document, and it always references a purchase agreement, a purchase and sale agreement. Sometimes it'll reference a forward flow agreement. This is the actual underlying contract that the parties enter into, the original creditor and the debt buyer, that covers the sale of different accounts. Now, this document is almost never disclosed without the court forcing them to do it. They do not want these documents out in the open because these are the documents that give the debt buyer power to sue on the case, but it also gives a lot of the details and the disclaimers and the lack of warranties on the accuracy of a lot of the information. So they don't want these things out there. So I will always ask, I'll point this out, I'll say here, in the bill of sale that you just had introduced into evidence, it states that the contract that governs the agreement, that tells us all the information we need to know about this, tells us which accounts were included. Have you ever seen that document? Have you ever personally read it? 99% of the time, the answer is no, they haven't. They haven't even seen the document. It hasn't been disclosed, but they haven't seen it. Even their own witness hasn't seen it to be able to testify about the information that's in there. And then I'll say, has that been disclosed in this litigation? And they'll say no. And then I always say, why not? And the reason why I ask that one extra question is because almost all these witnesses have been trained to just kind of lose it. They start saying, "Oh, it's got trade secrets in it," and they put up this really strong defense of why they shouldn't have to disclose that. That may work in the business world, but in the legal world, it's a little bit fishy when the document that governs your entire transaction, you don't want anybody else to see. You don't want the courts to see it. You don't want to provide it to the person that you're suing, so that can be problematic for them. And so that is really, those are, I'll leave it at that, but those are the main questions that I ask. Sometimes there'll be some follow-up questions if they say something bizarre, about different documents. But those roughly, 5 areas of questioning, those are the ones I really dive into because I want to paint the picture to the court that this witness, not only did they just look at the documents a couple hours before trial, they don't have any training from the original creditor, they didn't reach out and verify the amounts owed with the original creditor, and they just don't have the information that's needed to be able to testify like they're trying to do. So hopefully that's helpful and demystifies cross-examination a bit. Key thing to remember is to be prepared. There is no shame in writing each of these questions down and going into court and reading them off of a piece of paper. You can stand before them with your yellow pad and read it. There's no points for style. You want the information out there. You're going to be nervous. Attorneys are nervous. Even when they have done it 1,000 times, there's always a little bit of butterflies in doing it. So be prepared. Practice. This is something you can do. Write them down and stand up and speak out loud. When I'm doing opening statements, closing arguments, I always practice in my office. I shut the door and I talk out loud and practice that so I feel comfortable when I get into trial. I don't want the first time when I say something or present an idea or an argument to the court to be when I'm standing there. I want to have done it many times before so that I'm fully prepared to put my best case forward. So hopefully that's helpful today. Again, if you're dealing with a debt problem, particularly with a junk debt buyer, check out some of the other videos here on my channel. Go ahead and click subscribe, and you'll get access to all of those as soon as they're released. Thanks for watching today.